Valid trust. Validity of trust and enforceability. After Sally's death, to create a valid private express trust in Florida, a settlor must have I. Capacity, 2. Present intent to create a trust, 3. Property, or res distributed to the trust, 4. Ascertainable beneficiaries, v. At least one trustee, and 6. A valid trust purpose. This trust seems to satisfy all such elements, and is therefore a valid trust. The settlor must have the proper capacity required for the type of trust created. Florida defaults to a revocable trust, unless there is clear language stating that it shall be irrevocable. An irrevocable trust will require the same capacity needed to permanently make a gift or irrevocable transfer. That is, they must understand the consequences of the instrument, awareness of what is being given and to whom, and not be under any means of duress or incapacity. Present intent requires that the settlor intended to clearly make this instrument enforceable at the time it was signed, and not at a later date. The trust must have property owned by the settlor actually transferred into its possession to be valid, unless it is a testamentary pour-over trust. A trust must have valid ascertainable beneficiaries. The trustee must be named and must be accept the role of trustee. Evidence of acceptance can be proven by their actions using the power of trustee. A trust must have a valid purpose that is not illegal or against public policy. A trust will be valid after the death of the settlor if the trust meets the requirements of a testamentary instrument, such as a will. A will requires a written instrument with the testator's signature at the bottom, as well as 2 witnesses. The same requirements of no duress, incapacity, or illegal influence apply. Modification or termination of the trust without court involvement. After the death of the settlor, an irrevocable trust may in certain circumstances be modified without court involvement, if all the trustees and beneficiaries unanimously agree that the trust no longer serves its material purposes. However, the trustee can deny such modification or termination if in good faith he or she believes that the trust still has a valid purpose. Judicial modification or termination of irrevocable trust. In addition to modification or termination through a trustee, beneficiaries where a settlor is deceased can seek judicial modification or termination of a trust that's purpose is materially being frustrated. The court must find that the initial purpose of the trust is not valid, not feasible, or not in the best interests of the beneficiaries based on the current situation that was not considered at the time of trust creation. The court will look to the intent of the settlor both through express trust provisions and extrinsic evidence for guidance. Grounds to remove Tom as trustee. A trustee has many duties to the beneficiaries, such as a duty of loyalty, duty to diversify assets, etc. Included in that duty of loyalty is the general standard of acting in the beneficiary's best interests. Breaches would include self-dealing, conflicts of interest, commingling funds, and failure to abide by these duties can be grounds for removal. Absent express language, beneficiaries cannot remove a trustee without cause. Trustees also have a duty to inform, which includes providing accounting of the trust to the present beneficiaries, no less than annually. Trust is valid. A valid trust is formed when a settlor with capacity has present intent to create a trust, has a trustee with duties, has identified beneficiaries. If a private trust, settlor has the right to the trust property and the trust is for a valid purpose. A trust need not be in writing unless it conveys real property or is a testamentary trust. Delivery of the trust residential is required unless a self-proclaimed trust. Note, merger occurs when the settlor of a trust is a sole beneficiary and the trustee. Valid trust. A valid trust is formed when a settlor with capacity has present intent to create a trust, has a trustee with duties, has identified beneficiaries. If a private trust, settlor has the right to the trust property and the trust is for a valid purpose. A trust need not be in writing unless it conveys real property or is a testamentary trust. Delivery of the trust residential is required unless a self-proclaimed trust. Trusts are presumed revocable unless the instruments say otherwise. Settlors may revoke or modify the trust during their lifetime. This trust is also valid for all the same reasons as the first trust, see above. Spendthrift clause. A spendthrift clause is one that prevents beneficiaries of a trust from voluntarily or involuntarily alienating their interest in a trust. This type of provision in a trust prevents a beneficiary's creditors from attaching to their interest in the trust. Exception applies to the following creditors who can attach notwithstanding a spendthrift provision: child support, alimony, government creditors/taxes. Also, a settlor cannot shield himself from his own creditors with a spendthrift provision. Discretionary trust. A provision in a trust that makes distributions discretionary is valid. The trustee has broad discretion as to when to make distributions when there is a discretionary clause. Discretionary clauses also insulate beneficiaries from creditors because they have no right to distribution, thus, their creditors have no right to compel a trustee to distribute. Homestead exception. In Florida, homestead exemption applies to prevent creditors from attaching to the interest of an owner of homestead property. The scope of homestead protection extends to 1/2 acre of land within the municipality, including the residence only, and up to 160 contiguous acres outside the municipality, including improvements. Exceptions to the homestead protection include creditors such as mortgage on the property, mechanics liens, and property taxes. The proceeds from the sale of a homestead are also protected so long as the owner intends to reinvest in another homestead within a 16 reasonable time. Once reinvested, the surplus, if any, from the sale of homestead property is not protected. It is a general asset to which creditors may freely attach. Validity of the trust. In order to be a valid trust, a trust must be executed with the proper formalities, by someone with capacity to execute the trust, with trust assets, res, with the intent to place those assets in trust, for a lawful purpose, for a beneficiary, and administered by a named trustee. Testamentary capacity. Turning to the requirements for all trusts, first, the capacity to create a trust requires that Sally, as the settlor, have understood the effect of the document as well as her natural bounty. Because the trust is revocable, it need not meet the higher standard for capacity applicable to wills and irrevocable trusts. Trust res. Second, the trust must have a res, or assets, within it, with the limited exceptions of pour-over trusts or life insurance trusts. Intent. Third, Sally must have had the intent to place the assets in trust, which can be inferred from the trust document itself. Lawful purpose. Fourth, the trust must be for a lawful purpose. Trustee breach of loyalty. Regarding breach of fiduciary duty, as trustee, Ted owed two sets of duty to Ben as beneficiary, a duty of loyalty, and a duty of reasonable care in the administration of trust assets. With respect to the duty of loyalty, it is a per se violation for a trustee to engage in self-dealing. Termination of a trust. A trust can be terminated when consistent with the settlor's intent. So long as the settlor is living, this may be done by consent of all the beneficiaries and the settlor. However, Sally, the settlor, is dead. When the settlor has died, the trust may be terminated by unanimous consent of the trust beneficiaries so long as doing so would not conflict with the material purpose of the trust. Among material purposes for trusts are spendthrift clauses, or other clauses designed to limit the discretion of the beneficiary to dissipate trust assets. Spendthrift. Spendthrift clauses constitute a material purpose barring trust termination without the settlor's permission. Validity of a trust. To create a valid express trust, the following elements must be satisfied: capacity, present intent to create trust, trustee with duties, trust property, res, ascertainable beneficiaries, and a valid trust purpose. Under Florida law, a trust is presumed to be revocable unless otherwise stated in the terms of the trust. Capacity. To satisfy capacity, the settlor should be 18 years or older and manifest the same capacity as required to create a will. He must know the nature and extent of his property, the natural objects of his bounty, and the effect of the disposition. Present intent. Next, the settlor must demonstrate a present intent to transfer property to a trustee. This should create a legal obligation and should not be a hope/wish or any use of precatory language. Trustee with duties. Third, there must be a trustees with duties. However, a trust will not fail for lack of a trustee, as a court can appoint one. Also, unless it's a lifetime transfer in trust, a sole trustee may not also be a sole beneficiary. Otherwise, legal, trustee, and equitable, beneficiary, titles merge and the trust fails. A trustee can be removed if 1. He violates a breach of trust. 2. Fails to administer the trust effectively. 3. There's a change in circumstances. 4. All qualified beneficiaries agree to remove the trustee. Trust res. Must include valid trust property that is identifiable from other property. Ascertainable beneficiaries. The beneficiaries must be identifiable persons with a present or future interest in the trust. However, there are exceptions for unborn children and charitable trusts. Valid trust purpose. Trust can be for any valid purpose as long as it is not illegal or against public policy. Spendthrift provision. A spendthrift provision prevents the voluntary or involuntary transfer of a beneficiary's trust interest, thereby limiting the ability of creditors to attach to the beneficiary's interest. However, there are a few exceptions that apply under Florida law: child/spousal support payments, judgment creditors, Fed or Florida government, a settlor who is also beneficiary of the trust. Taunton trust. Money trust may also be a valid Taunton trust. A Taunton trust uses a bank account to deposit funds for the benefit of another beneficiary. Trust valid. A trust is a fiduciary relationship between a trustee, one who has legal title, for the benefit of the beneficiaries, hold equitable title. There are express trusts, can be private or charitable, resulting trusts, those that are created when there is a reversionary interest for the settlor, and constructive trusts, created to prevent unjust enrichment, as a result of fraud, misrepresentation, illegality, etc. In order to have a valid trust, there needs to be a settlor with capacity to convey. The settlor has to have the present intent to place the property in trust, can be written or oral, and it cannot contain precatory language: I wish, hope, desire. A trustee must be 18 years or older and have capacity to enter into a contract, be of sound mind, that has been assigned duties by the settlor, an ascertainable beneficiary by the time the trust is to come into enjoyment. If the assigned beneficiary does not disclaim his interest, he is presumed to have accepted the trust, valid property or res, valid trust purpose. In addition, the sole trustee must not be the sole beneficiary and the trust must vest from 21 years of the death of a life and being at the time the trust was created or within 360 years, Florida requirement. Unless the trustee was written prior to December 31, 2000, then it must vest within 90 years. Discretionary trust provision. A discretionary trust is one where the trustee has discretion on how to make trust distributions for the beneficiaries. The trustee shall do so following the instructions or duties assigned by the settler's intent. A discretionary trust also prevents a beneficiary from demanding a distribution. The trustee has sole discretion as long as he follows the settler's intent. Payment to trustee. A trustee shall be allowed to receive reasonable compensation from the trust. A reasonable compensation, if not stated by the trust, would be one that when you take into account the skill of the trustee, the time spent administering the trust, and the amount of the trust would be reasonable. Exculpatory clause. Exculpatory clauses in trust can relieve the trustee of liability. However, if the exculpatory clause is found to have been a result of undue influence or the clause is one that prevents the trustee from being liable for bad faith/reckless behavior, the exculpatory clause will be found invalid. Duty of good faith/impartiality/loyalty. A trustee has duties to administer the trust with good faith and in a prudent manner. He has a duty of loyalty, no self-dealing, duty of impartiality, take the needs of beneficiaries into consideration, duty to earmark trust and prevent commingling, duty to report, duty to preserve and make trust productive, and duty to act as a prudent investor. Breach of trustee, remedies. When it is found that a trustee breached his duties, the court shall award specific performance, order an injunction to prevent trustee from continuing breach, order to pay damages or to restore property, whichever is greater, or he shall be removed as trustee. Trust would not fail for this because court could appoint another. Trustee removal. Qualified beneficiaries, settler or co-trustees, can ask the court to remove trustees and the court will do so if it finds that keeping trustee is detrimental to the administration of the trust. If 1. Lack of co-trustee cooperation. 2. Failure or unwillingness to run/administer the trust. 3. Substantial change in circumstance. 4. Breach of trust duty. Termination of trust. Termination of a trust, creation of resulting trust. A trust can/will terminate when the trust indicates it shall terminate, achieved its purpose, or if beneficiaries, trustee, and or settler consent and ask for it. Charitable trust. The Attorney General, run/in charge of charitable trusts, has the power to demand action from/for charitable trust. Charitable trusts are those who have ascertainable beneficiaries, usually look at the general public, and must be for a charitable purpose, furtherance of religion, education, government, health. Charitable trusts are also not subject to the rules against perpetuities, can last forever, indefinite. Valid trust. To have a valid express inter vivos trust you must have, 1. A settler, 2. Intent to create a trust, 3. A trustee, 4. Definite and ascertainable beneficiaries, 5. Proper trust res, 6. And a legal purpose. While a settler may also be a beneficiary of a trust, they may not be the sole trustee and beneficiary. If a trust is testamentary in nature, it must be executed with will formalities. While generally allowed to be oral, the statute of frauds does require that trust involving transfers of real property be in writing. A trustee may be anyone 18 years of age or older who has the legal capacity to enter into legally enforceable contracts. Beneficiaries must be definite and ascertainable. Even if beneficiaries are a class, members must be readily ascertainable, unless a charitable class, in which the opposite is true. Future proceeds from existing contracts are valid as trust property as they are certain to be realized. Any purpose which is legal in nature is considered proper purpose for the creation of a trust. Trustee. If a trust has co-trustees, it will not fail if one or even both of the trustees subsequently die or withdraw. The court will appoint a trustee in replacement or the settler may appoint a new trustee. A trust is also presumed to be a revocable trust during the lifetime of the settler, unless expressly stated otherwise or until the settler dies. The divorce of a settler and their wife will eliminate any interest the ex-spouse had prior to divorce if considered a will substitute. While this can be separately contracted around, the contesting party, i.e., the ex-spouse, must prove by clear and convincing evidence of such intention. Since a trust can be a will substitute, if it is such it must comply with will formalities, i.e., 2 attesting witnesses signing in the presence of each other and the testator. Also, trust beneficiaries are subject to the statute of frauds in that a trust benefit must vest or fail within 21 years of a life or being, or actually vest or fail within 360 years of creation. Trustee/beneficiary. When the trustee of a trust also becomes the sole beneficiary of the trust, there is no separation of equitable and legal title and thus the trust will fail. If the trust fails for this reason, the trust property will be disbursed to the beneficiary, who will also be the trustee. Trust creditors. The creation of an irrevocable trust protects the settler from the reach of creditors as to the trust property. However, if it is found that the creation of the trust was made solely for defrauding a settler's creditors, the trust will fail. Spendthrift trust. A trust can include spendthrift provisions that can prevent a beneficiary from being able to voluntarily or involuntarily transfer their interest in the trust, i.e., they cannot assign their right to disbursements. Additionally, the creditors of a spendthrift beneficiary cannot reach the trust property. They can only place a claim to the beneficiary's interest in the trust once the property has actually been disbursed. An exception to this applies to state creditors and claims for spousal support and child support. These special creditors can still reach the assets prior to disbursement. Honorary trust. In Florida, honorary trusts are allowed. An honorary trust may be set up for the purpose of providing for a pet once the settlor has died, or to take care of a grave site. The statute of frauds applies to honorary trusts set up for pets, and the trust will only continue for as long as the last pet who was alive at the time of the settlor's death has also deceased. Validity of the trust. A valid private trust requires 1. A settlor, 2. Who delivers, 3. Legal title to trust property, 4. To a trustee with enforceable duties, 5. For the benefit of beneficiaries, 6. With the present intent to create a trust relationship, and 7. A valid purpose. A settlor is a property owner with the capacity to convey property. Inter vivos. If an inter vivos created during the settlor's lifetime, trust is created in favor of a third party, then the settlor must deliver the property to the trustee. No delivery is needed when the trust is testamentary, effective at death, or when the settlor is the trustee. A trust will not fail for lack of a named trustee, or if the trustee disclaims the position or resigns. Instead, if another person is named in the trust instrument, they will be appointed trustee, or a court will appoint one. Also, a settlor can be both the settlor and trustee. The only prohibition is on a person being the sole 14 trustee and the sole beneficiary, as there must be someone to enforce the trustee's fiduciary duties. A trust must contain ascertainable beneficiaries. This is valid under Florida law as long as T exercises it within a reasonable time. The settlor must have the present intent to create a trust relationship. This means he must intend to convey legal ownership on one party to manage the property for the benefit of the other. Lastly, a trust must have a valid purpose. This is liberally construed and means it must be a legal purpose and cannot violate public policy. Examples of trust purposes that have been found to violate public policy are 1. Restraints on the ability to enter into a marriage, 2. Restraints on freedom to practice one's religion, 3. Encouraging divorce, and 4. Encouraging the commission of a crime. Spendthrift trust. A spendthrift trust prevents voluntary or involuntary alienation by a beneficiary of his interest. This is included because the general rule is that a beneficiary can freely transfer his interest in the trust, subject to any conditions on it. To be valid, the provision must prohibit both voluntary and involuntary restraints on alienation. The effect is that the beneficiary cannot voluntarily convey his interest, and the beneficiary's creditors cannot reach his interest. Although spendthrift provisions are restraints on alienation, they are valid and enforceable in Florida. The exception to this is that they are not enforceable against the settlor's creditors. A settlor's creditors can reach trust assets if it is a revocable trust or an irrevocable trust where the trustee has discretion to make distributions to the settlor. Generally, a creditor of a beneficiary can reach whatever amount the beneficiary is entitled to. However, there is an exception to this protection for child support or alimony arrearages. Trustee compensation. Trustees are entitled to reasonable compensation for administering a trust. The amount paid to the trustee is deducted from the trust res, 1/2 from principal and 1/2 from income. The amount of compensation can be set forth in the trust instrument. Trustee duties. A trustee owes various duties to the trust. He must act as a reasonably prudent trustee, exercising reasonable care in his administration of the trust. He must invest prudently, which is judged under the prudent investor rule. Also, he has a duty of loyalty to the trust and the trust beneficiaries. This means the trustee owes an undivided duty of loyalty to the trust and beneficiaries. The duty absolutely prohibits any self-dealing, and when committed, it constitutes an absolute wrong. Breach by trustee, damages. They could recover the profits the trustee was making as a result of his breach. T could raise various defenses such as, 1. The beneficiaries consented, 2. He was released by 2/3 of the trust beneficiaries, 3. His breach was ratified, or 4. Reasonable reliance on the trust instrument. However, none of these defenses appear to be viable on these facts. Likely, a court would find that the fee T took was a violation of his duty of loyalty and that the beneficiaries are entitled to damages. Generally, damages for breach of the duty of loyalty are the greater of 1. Replacing the trust property to what it would have been absent the breach, or 2. Recovering the profit the trustee made from the self-dealing. Validity of the creation of the trust. In order to create a valid trust, the following requirements must be met. There must be a settlor. The settlor must have the capacity to convey, both the intent to convey and the ability to think clearly in disposing of the property. There must be trust property, the res, which must be property that the settlor has a vested interest in and cannot be solely contingent. There must be a trustee. Although a trust will not fail for want of a trustee, in Florida, a court will appoint one if there is no trustee, there must be identifiable beneficiaries, and there must be a valid/legal trust purpose. A trust that is executed with the intent to dispose of property at death must further meet the requirements of the statute of wills, i.e., must be in writing, signed by the testator as well as two witnesses in the presence of each other. In Florida, a trust that does not indicate whether it is revocable or irrevocable is deemed to be revocable under law, so long as trust was created post-2007. Standing to challenge. Any beneficiary of a trust has standing to challenge the trust or can assert a claim that the trust must be distributed in a particular way. Trustee's duties. A trustee is required by law in Florida to avoid self-dealing, act prudently in investment decisions, and owes a duty of good faith and loyalty. A trustee who has particular experience in managing a type of asset is held to a higher standard of care than someone without such experience. In Florida, where there is more than one trustee, the trustees must make decisions jointly and are not permitted to divide up the administration of the trust among themselves without all taking an active role in trust administration. Valid trust. A trust is legal title to property in one person for the benefit of themselves or others. In order to form a valid trust, there must be a legal purpose, intent to create a trust res, i.e. trust property, ascertainable beneficiaries, a trustee who is not the sole beneficiary and sole trustee, a settlor with legal capacity, and it must be in writing if the property includes real property, and comply with statute of wills if testamentary. Here, there is a legal purpose. Any purpose is sufficient so long as not an illegal purpose, to devise life insurance proceeds. The intent of Susan to make a trust is clear by the fact that she created it. The trust property is the proceeds of Susan's life insurance policies in effect at the time of her death. This is a sufficient interest and proceeds to qualify as the trust res. The beneficiaries must be ascertainable in order to form a valid private trust, as opposed to a charitable trust, which requires unascertainable beneficiaries. Here, the beneficiaries were named as Susan's surviving children and others as the trustee in his discretion may deem appropriate. Florida allows a class to qualify as ascertainable for purposes of beneficiaries, and therefore, the class of Susan's children is sufficiently ascertainable. The discretionary language giving power to the trustee would likely be considered a discretionary power of appointment, allowing the trustee to decide who else may be a beneficiary. Express trust. Private trusts can be express, resulting, and constructive. An express trust, like the trust created here, is one where the trust is made to settlers' indications. A resulting trust is one that arises when a trust ends and fails, and there is still trust property. Prudent investor. The prudent trustee rule requires a trustee to invest prudently. The measure of prudence is based on the time of the investment. A trustee with special skills or expertise is held to a higher standard under this rule. Duty of loyalty. Self-dealing is present when an investor uses trust funds to benefit himself. Spendthrift trust. A spendthrift trust is a trust that includes a provision restricting any voluntary or involuntary transfer of a beneficiary's interest in trust assets. Spendthrift trusts, however, do not protect from a transfer of the interest to pay alimony, child support or government taxes or payments. Constructive trust. Constructive trusts are meant to equitably allocate trust property under 5 situations: theft, breach of fiduciary duty, homicide, breach of promise, and fraud. The court will consider extrinsic evidence to determine the rightful beneficiaries of the trust. Valid trust. A valid trust requires 7 elements: settlor, intent, trustee, beneficiary, sole trustee can't be sole beneficiary, trust property, and a valid purpose. Trustee duties. A trustee cannot purchase real property without authorization in the trust or order of a court. But, the property can be titled in the name of trustee and kept as a trust asset, the asset being principal and the rent being trust income. Resulting trust. Resulting trusts are not actual trusts but instead imposed by courts to dispose of a purchase money trust, to pass a beneficiary's interest if her gift lapses, and to dispose of the corpus of a trust. Valid trust. To create a valid trust in FL you need intent by the settlor to create a trustee, although trust won't fail for want of a trustee, trust property, res, delivery of the residential to the trustee, and ascertainable beneficiaries, or charity beneficiary. The creator must also have capacity, and there is nothing in the facts that seems to negate his capacity to create the trust. While a trust agreement need not be in writing, a testamentary trust must abide by the statute of wills, which requires 2 witnesses. Inter vivos trust. In an inter vivos trust, the settlor need not transfer trust property to himself if he names himself trustee, no need for a strawman. An inter vivos trust in FL can be revocable or irrevocable depending on the language of the trust. Trust termination. Florida law allows the beneficiaries to a trust to terminate it and obtain the principal if all agree, and terminating the trust will not be contrary to a material purpose of the trust. However, trusts with spendthrift clauses and fixed periods cannot be terminated in this fashion. Spendthrift trust. Creditors can generally reach a beneficiary's interest in a trust unless the trust includes a spendthrift clause. By adding a spendthrift clause, any creditor will not be able to attach the beneficiary's interest unless the creditor provided necessaries to the beneficiary or a former spouse seeks to collect past due alimony or child support payments after all other avenues of recovery have been exhausted. Revocable trust. Trusts are irrevocable unless the settlor specifically reserves the right to modify or revoke the trust. Simultaneous Death Act. Florida has adopted the Uniform Simultaneous Death Act, which states that if two people die at the same time, it is presumed for purposes of divising their property that they survived the other. Florida has not adopted the rule that the spouse must survive the other spouse by 120 hours in order to take it out of the act. Valid will. A person has a right to create a will and devise his property however he sees fit, with some restrictions by statute. The mutual injunction against the sale, transfer, damaging, or otherwise dissipating or disposing of any assets in this case will not likely have any prohibition on the creating of a will. Gifts in the will can be deemed if the property is no longer in the estate at the time of the testator's death. Elective share. An elective share allows a spouse excluded from the will to recover 30% of the elective share estate, which is larger than the intestate estate. Included within the elective estate are all transfer and property within a year preceding the decedent's death, inter vivos trust, bank accounts, etc. Constructive trust. A constructive trust is an equitable remedy the court will award if someone has title to certain property through wrongdoing, and the court enforces this to disgorge unjust enrichment and give the property to the rightful owner. Elective share. If there is no agreement, prenup, then a spouse in FL is entitled to 30% of the elective estate. Charitable trust. A charitable trust, unlike a private trust, must not have specific beneficiaries. It must be for the goods of the general public. Causes such as education, religion, science, public service are valid charitable trust beneficiaries. Under the Restatement of Trusts, in this situation, where the beneficiaries are unascertainable and the settlor gives his intent to promote the power to appoint, the Restatement of Trusts says to allow the appointment because it is most in line with his intent. However, a majority of states at this time hold the opposite. They find that the power to appoint renders the trust invalid for purposes of unascertainable beneficiaries. Resulting trust. Any part of this estate that fails would result back to the estate. Elective share. A spouse has a right to take an elective share upon the decedent spouse's elective estate equal to 30% of the elective estate. Property included, among other things, in an elective estate includes the settlor's interest in a revocable inter vivos trust.